If you come to my office and we're talking about a criminal defense situation, you've been arrested and charged with a crime, and we're going to discuss plea bargaining, what is it about the plea bargaining that we are going to evaluate when we're talking to you about the case, and how do we know what is the likely resolution on your case? Well, first and foremost, we're going to have an idea of what the resolution on your case, what a plea bargain offer, what an offer on a plea is going to be from our prior experience, from dealing with prior cases similar to what you have been charged with. The laws don't change greatly, so if you're arrested and charged with a petty larceny, that's the one that comes to mind most regularly for me. Let's say you've got charged with a petty larceny from a Kohl's or a Walmart here in the Hudson Valley, because I know that petty larcenies come out of those stores pretty regularly. What is a likely resolution going to be on that case? Well, first of all, did the store recover the property that they claim that was stolen, that they claim that you stole from the property? Were there any aggravating circumstances? Was there a resisting arrest charge? Do you have a prior conviction? Do you have a prior criminal record of any sort? If you have a prior criminal record, you can be guaranteed that the district attorney's office is going to take a harder line with a plea negotiation. But most of the time, if we're talking about a first offense, petty larceny, the store's recovered the property, and there's no aggravating circumstances surrounding the arrest, it's probably going to be a situation where they're willing to grant you what is called an adjournment in contemplation of dismissal, or the jargon term is an ACD. What does that mean? That means that as long as you are not rearrested within a 6-month time frame or a 1-year time frame, whatever it is that the judge and the district attorney and the defense attorney all agree upon, but oftentimes it's 6 months. If you're not rearrested, the charges will be dismissed. The record of your arrest will be destroyed. The fingerprints and the photograph will be destroyed. So there will be no record. You won't be convicted of a crime. That is a normal resolution. And then depending on what the crimes are that you have been charged with, that's that's what we're going to be able to gauge what a likely plea offer is going to be. There really are not resolutions on cases, plea bargains on cases that are wildly different than the next one, unless there's some serious reason, some aggravating circumstance that causes the district attorney's office to take a harder line with you. And that would be things, again, like you have a prior record, you gave the officer a hard time when they were arresting you, or something like that. Injuries, obviously, if there's a victim in the case and somebody was injured, that's always going to affect it. If it's a domestic violence situation, that's always going to affect the plea bargain. It's really your choice as a client of ours as to whether or not you want to accept a plea bargain, or you want to pursue the defense of the matter, the defense of the case any further. So these are all things we're going to talk to you about. Sometimes it's in your interest to take the plea. Sometimes, you might be able to get a better resolution on the case. It's all things that you have to talk to your attorney about when you get that plea offer and before you accept it.